Monsieur le Président, Mesdames et Messieurs les
President,
permettez-moi de débuter
judges,
mon intervention
allow me to begin
par un rappel de deux principes
by recalling two fundamental principles. Freedom of expression does not secure or guarantee an absolute right. However, the authorities cannot limit their exercise arbitrarily or in a disproportionate manner, but must abide by certain conditions. Indeed, restrictions must be provided for by law, must be necessary in a democratic society. Freedom must be the rule and all restrictions the exception. It is also important to recall that in this case, your court is not called upon to determine the reality of the mass killings perpetrated against the Armenian people as of 1915, or whether it is appropriate to characterize this as genocide under the Swiss Criminal Code. I refer to the judgment of December 2013. The decision is whether or not freedom of expression protects the right of the applicant to challenge the legal characterization as genocide of such tragic events given by the authorities of a third country, Switzerland. Our client indeed never challenged that there were massacres and deportations, never condoned them, never tried to stir up hatred against Armenians, as is illustrated by the judgment of 17 December 2013. Upon reading the written observations submitted by the Swiss government, the most recent observations, we find some confusion in this regard, in our opinion. Hence, it is important to recall that, in our opinion, the case before us cannot be settled on the basis of principles you have set out in your case law regarding hate speech or those pertaining to the denial of the Holocaust. I reiterate, our client, the applicant, never denied the crimes committed from 1915 onwards, and quite clearly does not have any intent to infringe freedoms. The matter at hand is quite different, that of the scope of the right to defend minority opinions that could fuel debate on controversial issues that have not been settled. And once again, I refer to the judgment of 17 December 2013. In this context, we would like the guiding principles that have guided you in your case law to date be applied in this particular case as well. First of all, the principle according to which freedom of expression applies not only to ideas and opinions that are generally acknowledged or are not offensive, but in particular for ideas that also might be disturbing or shocking. Another principle that you have set out is that research, historical research, seeking historical truth is part of freedom of expression. It is not up to the courts to seek to define historical truth, while such truths are still controversial. And finally, the principle according to which the passage of time must be favorable to freedom of expression. To come back to the case at hand, it also seems logical to us to protect, in light of these guiding principles, the right to dispute the legal characterization given to the tragic events of 1915 by the Swiss courts, while your court, in its case law, has found not in conformity certain descriptions regarding tercity. So I think consistency of the case law is of the essence. Using the concept of genocide or punishing it on the ground that it might be a threat to the identity of a group, in our opinion, is incompatible with freedom of expression because the concept of identity is extremely vague, and accepting this would leave the door wide open to abuse. The Swiss courts have often referred to identity in relation to dignity. According to us, this concept of identity should only be used with great caution, since we do not know how a court could objectively decide what historical tragedies have contributed to or at the heart of a national identity, the identity of a community, and why it would be prohibited to use another characterization than that approved of by one House of Parliament, for example. The judgment delivered on 17 December 2013 should be commended and welcomed, for its detailed, accurate analysis of recent developments in comparative law. The constitutional courts of Spain and France in November 2007 and February 2012 were referred to and analyzed in detail in the aforementioned judgment, but I would like to draw your attention to Article 19 of the International Covenant on Civil and Political Rights to recall a fundamental principle under Article 19 and the Spanish and French case law that confirmed that criminalizing opinions pertaining to historical events because they could be inaccurate or offer an inaccurate interpretation of past events is not consistent with freedom of expression as secured by Article 19 of the ICCPR. Every state is, of course, free to recognize officially or not a particular event as a genocide, and one might think that such an approach is more conducive to differences of opinion and creating a divide rather than reconciliation. It doesn't seem appropriate for states to pass laws on tragic events suffered by others in which that country was not involved either directly or indirectly. In any event, we challenge the compatibility with Article 10 of the Convention of any implementation of a criminal provision criminalizing the challenging of the legal characterization given to historical events. In these troubled times, we find it important to recall that one of the main purposes of freedom of expression is to protect opinions that might not be popular, whether in Switzerland, in Turkey, or elsewhere. The Swiss government raised a number of arguments to justify the existence and implementation of Article 261 bis of the SCC, the Swiss Criminal Code, the drafting and wording of which is quite vague and unforeseeable, clearly illustrated, according to us, by Judges Raimondi and Saijo. I'm sorry if I don't pronounce their names well, in their joint concurring opinion in the judgment of 17 December 2013. I will not reiterate all that was said in the judgment, but I would like to refer to the analysis made regarding the non-foreseeable nature of the interference in the instant case. Since we do not have very much time, we will emphasize two main points that, according to us, reflect an inaccurate interpretation of international law on the one hand and EU law on the other hand. First of all, the impugned provision of the SCC was justified by Switzerland's accession to the International Convention on the Elimination of All Forms of Discrimination, racial discrimination. According to us, this text does not set out an obligation to adopt specific criminal provisions or exceptional provisions regarding negationism, because if that were the case, most states would have adopted a similar provision on the basis of that convention. And in our analysis, we find that this is not the case, far from it. Article 19 of the Covenant of the United Nations, that was not mentioned in the most recent written observations of the Swiss government and other third-party interventions, whereas the UN Human Rights Committee has said that under Article 19 of the Covenant, laws that criminalize the expression of opinions on historical events are inconsistent with the obligations stemming from the Covenant and incumbent on states parties, among which Switzerland. As to EU law, described by the Swiss government and some third parties as evidence that criminalizing denial of any genocide is to date an obligation under the European Human Rights Protection Mechanism, we find that this is an erroneous interpretation. This is not surprising to the extent that the Framework Decision 2008-913 was controversial and stemmed from negotiations that lasted 7 long years. It was adopted after 7 years of negotiations because of a major conflict among EU states and within the EU Council. That decision, if you read it in detail, detail, comprises many exceptions to the general principles it sets out. I do not have the time to say a great deal in this regard, but EU law does not set out an obligation to punish condoning crimes such as genocide, or only if the intent of the speaker was to stir up violence or hatred against a person or a particular group on the grounds of their race or ethnic origin. In other words, EU law only sets out an obligation to punish comments that amount to hate speech. And there is no obligation to punish comments that challenge the legal characterization of past events. No specific legal provision, in our opinion, is required by EU law regarding negationism. And in truth, if you carefully read a report of the EU Commission of January 2014 on the adoption and implementation of the framework decision, the aforementioned decision, we find that 13 member states of the EU, as of last January, had deemed that it was not necessary to specifically criminalize denial, gross trivialization, or condoning of the crimes defined in Articles 6, 7, and 8 of the Statute of the ICC. And this is crucial regarding the framework decision, the decision explicitly recalls that it can never justify the adoption of measures inconsistent with, incompatible with freedom of expression. In any event, EU law does not govern a situation such as the one that we are dealing with in the instant case, for the good reason that Switzerland is not a member of the EU. However, more essentially, even if it were a member of the EU, these provisions of the EU law would not in fact be relevant in the instant case, since what we are dealing with is a speech that was historical, legal, and political, as is clearly set out again in the judgment of December 17, 2013. I refer to what is said by the second section of the court that described the comments of the applicant as historical, legal, and political. To conclude, it seems incompatible with your case law, as well as incompatible with international law and the underlying principles, or what we find in comparative law. It is therefore, it appears that freedom of expression has not been respected in the instant case. And we do not find that a provision such as that contained in the Swiss Criminal Code is required by the protection of human rights. Freedom of expression cannot abide state-defined historic truth that grievously infringes freedom of expression on the basis of an undue broadening of the legal concept of genocide, as well as the retroactive application of this concept according to the whims of an ephemeral majority at a given time in a country. Lastly, we'd also like to recall that many historians over the past years have championed the view that in a free state it is not up to political authorities to define historical truth or to define in the law, again, a state-defined truth. This approach could have serious consequences and repercussions for intellectual freedom, and I refer to a number of French historians, namely the well-known historian Pierre Nora, who have adopted the appel de Blois, a call on respect for freedom of opinion. We subscribe fully to this viewpoint and respectfully ask the court to take it into consideration. Thank you for your attention.